Uh, with that very stimulating presentation, we're now going to have an entire panel on Iraqi federalism, balancing federal and regional power under the Constitution. And it's a privilege to moderate a panel with such distinguished speakers. I've already had a preview of their presentations, and I think you're going to find them of exceptional interest and quality. My plan is to introduce all the panelists, then each will speak for a maximum of 15 minutes, after which we're going to have 5 minutes for panelists to exchange their ideas and reactions, and then the session will be open to the audience for questions. I'm keeping the introductions very brief because I'm keenly aware that every minute that I take to talk to you will be subtracted from the audience opportunity subsequently to ask questions. Our first speaker is going to be Ambassador Brent Rahim. She is the Ambassador of Iraq in Washington, co-founder and executive director of the Iraq Foundation. She's held the role of Senior Fellow for Iraq at the U.S. Institute of Peace. She has degrees from Cambridge and the Sorbonne, and a record of extensive research and publication on Middle Eastern topics. She's become a regular commentator on Iraqi affairs in the international media, in addition to authoring research and policy papers for the Iraq Foundation. We'll then hear from David Tafuri, who's a partner in Patton & Boggs. He's recently returned from serving as the U.S. Department of State's Rule of Law Coordinator in the U.S. Embassy in Baghdad. He designed and managed justice system assistance programs for the U.S. government and led a joint team of U.S. military and civilian personnel in drafting the plan to strengthen the Iraqi justice system. We at last will hear from Jason Gluck. He has served as a legal officer and constitutional advisor with the UN Assistance Mission in Iraq and is a senior rule of law advisor for the U.S. Institute of Peace Rule of Law Center. He is also the director of the U.S. Institute of Peace's Constitution-Making, Peace-Building, and National Reconciliation Program. We'll start with Ambassador Rahim.
Thank you very much. I'm not sure.
Oh, I'm sorry. Excuse me.
Well,
we'll correct.
Pass that
Yes.
along. I left the Iraqi embassy in Washington in 2005, so I just want to make it clear that I am no longer associated either with the embassy in Washington or with the Iraqi government in any way. Thank you, Anne. I, first of all, would like to thank Penn Law for this wonderful conference. Dean Fitz, thank you very much for your support of the conference and for organizing it. And of course, Dean Gadsden and the staff who helped put it together. We appreciate being here in this wonderful city, one of my favorite cities in the US. I also want to thank Faisal Strabadi for setting the scene broadly in such a way that I and my colleagues on the panel can pick up where you left off and perhaps expand on some of the points and add to them, although on one or two issues I don't quite agree with you. I'm not sure that I'll have a chance to raise those, but thank you very much for putting the broad picture. I want to concentrate on the challenges. There are many challenges that Iraq faces in the next 4, 5, 10 years. I want to concentrate on challenges, first, those that are associated with governance, and to begin with, constitution. What are the challenges that are posed specifically by the Constitution, but to sort of roll out from there and look at what lies behind the Constitution, and are there challenges not only in the language of the Constitution, but in the attitudes and the political outlooks of those who drafted the Constitution. Because I think it is really, the Constitution embodies some of the presuppositions, the political perspectives of the drafters. To begin with, the Constitution, as I think Faisal said, was written, he said it was written too early. And I perhaps agree with that. But more to the point is it was written too quickly. And it was written under great pressure. And the importance was to write it within a time certain rather than to write it well. And this has caused problems since the Constitution was drafted and ratified in 2005, and we're going to confront more and more of these problems unless they are rectified. So the issue of quickness, the issue of write down what is expedient, defer what we don't have time for, as Faisal said in terms of the Federal Council, leave language vague because we don't have the time to specify, has created a constitution that Faisal called incoherent. I would call it imbalanced, misleading, vague, and certainly the architecture of the Constitution. Nobody stood back and looked at the Constitution to see whether all the pieces fit together. In addition, one of the big problems inherent in the Constitution is that a full 20% of the population of Iraq did not participate in writing it. At the time of the writing, it was written by members of an interim parliament who were either from the Kurdish parties or from the Shia Islamic parties. Those two groups together substantially wrote the Constitution. There were no Sunni representatives in the group that drafted the Constitution. The Sunnis were brought into the process sometime in July 2005, after the draft had been completed, and essentially were presented with a fait accompli. They had very little input into any of the articles of the Constitution in the conceptualization of the constitutional structure. And as a consequence, in order to avoid a Sunni veto of the Constitution, and the Sunnis, because they control 3 provinces in Iraq, any 3 provinces could have vetoed the Constitution. In order to avoid a Sunni veto in the ratification of the Constitution, they added an article in the Constitution, Article 142, which stipulates that this Constitution, which has not been passed yet, which has not been ratified, will in fact be amended within 4 months of ratification. Now, I am not a constitutional expert, and somebody can correct me, but I wonder if there is any constitution anywhere that within its articles says it is going to be amended within a period of time, and so short of period of time. In other words, the framers of the Constitution, the writers of the Constitution themselves, recognize that this Constitution was woefully inadequate, that it needed to be addressed in a very quick period of time in order to bring the country together around it and to make it acceptable, not to one group or 2 groups, but to all the groups in the country. Again, because of the haste and because of the lack of clarity in the wording of the Constitution, and of course the lack of clarity in the wording reflects lack of clarity in the thinking. As I said, several issues, important issues, were deferred. For example, the Federal Council was deferred. Issues of the Constitutional Court were deferred, and some very important items were left hazy. One of them, of course, is Article 140, which addresses, it's called the Kirkuk article. It in fact addresses not just the issue of Kirkuk, but what Faisal Istabadi referred to as the disputed territories and so on. This was stated, but there was absolutely no definition of what this article meant, what the disputed territories were, or what the mechanism was going to be that would address Article 140. The Constitution gives very few powers to the federal government, very few exclusive powers. There are a few exclusive powers to the federal government, a few shared powers between the federal government, the regions, and the provinces, and everything else that is not stated is, in fact, part of the authorities and powers of the federal government, of the federated regions or the provinces. The exclusive powers that are given to the federal government are stated largely in terms of policy setting, not of implementation, but that the federal government will set policies for this, that, and the other. So first of all, those exclusive powers are too few. Faisal mentioned the fact that the federal government has no right in the Constitution to levy federal taxes. I can add to that that it has no right to collect revenue from hydrocarbon production and exports or to distribute revenue. It has no power to run anything that is in terms of services or regulatory, that has a regulatory aspect. In Iraq, the joke was, when this constitution was ratified and published, was that this was a federal government of weights and measures. I would suggest that to the extent that we have a functional federal government today, and I will be one of the first to say that it's not fully functional, that it's very deficient, but to the extent that it functions, to the extent that it runs anything, it is in spite of the Constitution and not because the Constitution has given it those powers. The executive branch of the government, the cabinet, has, in the vacuum of what the Constitution actually says, has chosen to interpret the Constitution as broadly as possible in order to be able to run the school system, the health system, social security, to run roads, to run transportation, trains, and so on and so forth. We may agree amongst ourselves that it is not the business of the federal government, that all these authorities should be devolved to the provinces, to the regions. To the Kurdish region, they are in fact substantially devolved because the KRG actually runs its school system, its health system, and so on. But the provinces don't have the capacity. So we may argue that this should not be, doing services should not be what the federal government does. But since the provinces don't have the capacity, somebody has to do it, and by default the federal government is doing it, not because the Constitution gives it that power, but because it needed to be done, and it chose to interpret the Constitution as broadly as possible in the federal government's favor. If we come to the federal government and the provinces, there is one very brief article in the Constitution saying that, the provinces will have there will be administrative decentralization, they have administrative powers, and this will be legislated by law. In fact, a law of the provinces was published, was adopted and by Parliament in 2008, and it came out as a huge disappointment in my view. Jason probably knows much more about this than I do, but in reading the law of the provinces, again you wonder, well, there is a good description of the elected provincial councils and what they can do, but the provinces also have a provincial governor who is the executive branch of the provinces. There is very little description of the authorities and the responsibilities of the provincial governor, and more to the point, there is nothing about how the federal government and the provincial government will coordinate in order to provide services, what the mechanism of coordination is, where are the delimitations of authority between the provincial government and the federal government. As a consequence of this, we have had numerous disputes between the federal government and the provinces, particularly since the provincial elections of 2009, which elected the provincial councils, and the councils in turn elected the provincial governor. There have been disputes over appointments of officials, including appointment of provincial officials, where the federal government has from time to time dismissed a provincial official, and the provincial councils came back and said, you can't do this. This is our prerogative. There have been disputes over who is responsible for services, and to be precise, bad services in a particular government. Who is responsible for failures in electricity? Who's responsible for failures in delivering clean water? Who's responsible for failures in education? And so on and so forth. But in my view, one of the most dangerous disputes that have arisen because of this failure to understand how the pieces are put together and how they relate to each other is in the area of security. Now, I should go back and say that a very close reading of the Constitution, of the exclusive powers given in the Constitution to the federal government, are the powers to run the security services, the army, particularly the army, and the intelligence services. But as I said, a close reading shows us that this is really for protecting Iraq against external threats. There is no explicit statement in the Constitution to say that the Iraqi federal government is responsible for internal security. Oh, goodness. Okay, I'll run. And there have been tremendous problems within the provinces, within Anbar, Najaf, including southern provinces, in other words, who are favorable to the present government, of who is in charge of security and who is responsible for security failures and who is in charge of appointing or dismissing security officers. I need to move very quickly. The Commission to review the Constitution in the spring-summer of 2005 presented a number of recommendations to correct some of these imbalances. The recommendations are all good in my view, but I don't think they go far enough. We need a much greater restriction of, or definition rather, of what executive authority is in the federal government, what is properly the domain of the federal government, what is the domain of the provinces, and how are these two going to interlock so that there is no confusion and no disputes that could lead to conflicts. I want to take up very briefly the issue of that Faisal mentioned, which is the question of the dissolution of the state. My view is that if one does not address the issues of these complexities that have not been adequately addressed in terms of the relative responsibilities and relationships, there will be an increasing move by provinces to regionalize. And the reasons are very simple. The Constitution gives the regions tremendous powers. In fact, what we have is not a federated region in the Kurdish area, we have a confederated region. And I think whatever people say, I think if one is very realistic about this, there's no escaping that fact. So if provinces continue to have disputes with the federal government, and the federal government continues to want to fudge the issue in order to retain power to itself, then I think more and more regions are going to want to opt for this confederated status. Faisal mentioned Basra as a province that might go that way. Anbar, for different reasons than Basra, more reasons of grievances against the federal government, will also go that way. And the question is, if more and more provinces choose that route, is there any more a sense in having a federal government? Will the federal government have any vestigial powers to govern? And what will it govern? And what, in fact, will be the point of having an Iraq that is united by a boundary, but not united by anything else? I would add to this, and if I may add one more issue, a non-constitutional problem that I think actually hovers over everything and informed the writing of the Constitution. Faisal alluded to this, the Constitution, and again, if you read the preamble, it'll become very clear, was written not with a view of building a nation and a state for the future, but with a view to redressing past grievances. It was a defensive document to protect people from falling prey to the same types of persecution that they were subject to in the past. This is so clear in the preamble that I think the preamble should be completely rewritten. And in fact, there are requests by a number of groups in Iraq to rewrite the preamble. The preamble assumes that Iraq is a loose connection of different communities and different groups, and that these communities don't necessarily constitute an Iraqi people, that they're all sort of loosely put together for geopolitical necessity, and there is a border around them. And the question is that because they are different peoples and different communities, this is how we should look at them, and this is how we should be apportioning power. So we have a majority Shia, a minority Sunni, a Kurdish group that is restive, and so on. And the Shia should always rule, the Sunnis will always be in a minority, the Kurds will always be a problem. I think this is more of an existential issue than Faisal, the one you mentioned. And if you want, I think that this notion that Iraq is simply a collection of different peoples who don't constitute a nation, and some of whom are more equal than others before the law, is really at the heart of the existential threat to Iraq, and lies behind the way this constitution was written. We need radical reforms, both on the constitutional and the legal and the political level, in order to avoid future pitfalls. Thank you very much. Sorry if I took too long.
It's excruciating to be a timekeeper when you're listening to such a lucid and eloquent presentation. I'm so sorry we couldn't let this go on much longer. David Tafuri?
Actually, Professor Mayer, we're going to switch it up on you if that's okay.
That's fine.
Is that all right?
Absolutely.
I apologize.
No problem.
I want to thank the University of Pennsylvania Law School and the National Constitution Center. It's an absolute pleasure to be here, Dean Fitz, Dean Gatson, and Professor Mayer, and to be on a panel with two people that I respect immensely professionally and can count as close friends. It's a real pleasure to be here today, and thank you all for coming. I want to continue the discussion of Iraqi federalism, but from a governance perspective, from a rule of law perspective, and to see maybe at the ground why it probably isn't going to work and why it's struggling right now. What we have, and I think it's become clear from the last two speakers, are two completely separate or almost completely separate entities. Kurdistan, the region, and Iraq, the rest of the nation, have been built up constitutionally and practically in two silos, and almost never the twain shall meet. There are no federal institutions whatsoever in Kurdistan. Think about that for a second. Even on matters for which there is exclusive federal competency in the Constitution, like security, the armed forces, not local security, but national security, or immigration and customs policy, or immigration in particular. There are no immigration agents on the border, on the northern border with Turkey. There is no Iraqi army in Kurdistan. It's the Kurdish regional security forces. And there are so few laws that actually, national laws that actually apply in Kurdistan, that it is, for all intents and purposes, a separate country. Why is this a problem? It is not, in my view, a problem because Baghdad needs to run Erbil, but because in any federation, the role of the central government is to exercise power in those areas where the subnational units, whether they're states, regions, or provinces, either can't effectively and efficiently exercise those powers on their own, or else where the exercise of that power by the state could prejudice a neighboring or other state in the country. And this is the harmonization, the coordination, the macro policy that the central government ought to fill. It can't do, the central government in Iraq can't do that. And bear in mind that while things seem to be running okay right now, it is only because, in my view, there is only one region, this highly autonomous area that enjoys unprecedented decentralized authority in almost any other federation in the world. But, as has been mentioned, the Iraq Constitution envisions a nation of regions. How many there are is undetermined, and that itself presents a problem. But clearly, every single province, and there are 15 others outside Kurdistan, has the option of overnight almost assuming those powers, those immense powers that Kurdistan enjoys today. Well, what does this mean? It means that, for example, on oil, the lifeblood of Iraq monetarily, each province that has oil could become a region and constitutionally doesn't need to share the money with anyone, the central government or any other state, province or region. Let's take something a little more mundane. Civil aviation is not a power that the central government has within its competency. Now, it can exercise that power right now because it is basically controlling most of Iraq outside Kurdistan. But constitutionally, you can see a situation where you have 16 different subnational units, each with their own civil aviation. And to fly from Basra to Erbil would literally require air traffic controller coordinating between 6 or 7 different jurisdictions. Environmental regulations. And here you see where the acts of one state can, in fact, prejudice another. Environmental regulations are a shared competency between the central and the regional governments, which means regional law trumps national law. And it doesn't do Kurdistan any good to act as responsibly as any region could if its neighbors won't. And there is no mechanism there for national coordination, at least constitutionally. I want to give you an example that might be nearer and dearer to our hearts. We're at the law school. Let's talk about the judiciary. Right now, there are 2 completely separate judicial systems operating in Iraq. And although there is a constitutional court, a federal Supreme Court, that is at the apex of both of them, the route of appeals, particularly on non-constitutional issues, ends at the courts of cassation. This is a civil law system, not a common law system like the one we enjoy. And it is a civil law system that has as impressive codes as you will find anywhere in the world, historically. Civil codes, criminal codes, procedural codes, they are the envy. Yet they were written at a time when Iraq was a unitary state, and they have not been adopted to the reality that it is now not a unitary state, and it has 2 completely separate judicial systems. So, for example, there is no mechanism to service a process between Kurdistan and the rest of Iraq, or gathering evidence or taking testimony. There is no, what we in the US call the full faith and credit clause, there is no equivalent in the Iraq Constitution. So you cannot actually execute or enforce judgments in Kurdistan, outside Kurdistan, or in Iraq, or in the rest of Iraq, in Kurdistan. Arrest warrants, resolving jurisdictional disputes, choice of law issues, which have yet to arise in Iraq, but conceivably could, because each region has the ability to rewrite their own criminal and civil laws, contracting laws, family laws. So there is this complete vacuum that I will tell you, until about a year ago, there was no answer for. And I will say the U.S. Institute of Peace convened the actors, the highest judicial officers from the 2 systems, and set out to discuss these issues. What they've done is resolved a lot of the problems through judicial decree, and it's actually operating much smoother than it did even a year ago. But there's no statutory solution. As soon as politics get in the mix and legislatures get in the mix, everything falls apart. And let me remind you that these are challenges being faced between 2 judicial systems currently in existence today, when the Iraq Constitution potentially envisions 16, with very little federal jurisdiction left over. Now, when we talk about federalism in Iraq, we immediately get drawn to this relationship between the center and the region. and you have to, because it's not a tenable long-term solution. But almost equally as problematic, in my view, is the relationship between the center and the provinces, the rest of Iraq, that has almost been described today as a unitary state. It is for intents and purposes, practically speaking. It's not because the Constitution sets it up that way. The Constitution is, in fact, internally inconsistent on what these provinces, the rest of Iraq, everything outside of Kurdistan is meant to be. In one place, it actually gives these provinces the exact same power that Kurdistan enjoys today, and in another place describes them as administrative units of the central government. The Supreme Court has weighed in on this issue in an advisory opinion, tried to split the baby and have it both ways, and was summarily ignored when the national government passed the law, the parliament passed the law actually setting out statutorily what the provincial powers would be, and took the much more restrictive view, the one where they are the administrative units. Well, what does this mean for them? This means, as Ambassador al-Rahim suggested, immense inefficiency in local governance. We just know from comparative experience that sitting in Baghdad, national ministers are woefully inefficient and ineffective at producing, delivering goods and services that meet the needs and preferences of local communities. Think about it. You have a minister of Health and Human Services that is trying to tailor the needs of 15 different populations, and in some respects, very different populations. You also have the folks on the ground working in these ministries reporting back to their paymasters in Baghdad and are not responsive to local government, even though it exists. What does this mean from the local government perspective? It means that the provincial powers and governors, even though they exist, have no ability at all to develop a common strategy for local governance. If a particular province says, well, actually our schools are okay, our roads are awful, we need to devote more money to roads. They can't do that. First of all, they barely have any money at all. And second of all, the management of an operation, the actual delivery of these services, are done through these silos in Baghdad. So the governor in one province can't say to the Minister of Public Works responsible for roads, we need a little bit more money. We're willing to sacrifice a bit on education or hospitals because those are okay, but we need more money for roads. They can't do that because it's 2 or 3 different ministers in Baghdad he'd be talking to, and one is not going to give more money for that province just because that province would be willing, in theory, to take less from a different ministry. So there's no central planning at the local level. What does this mean for the people? It means that the people can't vote with their feet, as we like to say. They can't leave a province with poor services and go to another province with better services because the provinces are all getting the same level of services from the national government. Although they're not, because a lot of times the delivery of services from the national ministries has as much to do with the politics and personalities between that specific minister and that particular governor than anything else. It's a horrible mess. And I do think that some degree of devolution at the provincial level is necessary, while simultaneously we need to take some power or empower the federal government vis-a-vis the regions. What would that mean? Well, I think what we would, if done responsibly, this would create more accountable, efficient, and effective government at the national and local levels, at the regional and provincial levels. It would decrease the motivation of these provinces to regionalize, and it would also rebalance the power around Iraq so that you don't have this bipolar struggle between Baghdad and Erbil, which is much more a political and existential conflict between the Kurds and Baghdad than it is a governance one. I want to end by saying my time in Iraq was in 2006 and 2007, and as an officer with the United Nations, I actually was one of the principal advisors to this parliamentary body tasked with reviewing the Constitution and providing a very comprehensive, although I agree with Ambassador al-Rahim, not complete set of amendments that have since been ignored by the Parliament, and I agree likely will be for the time being. But from that time, I do believe that the politics on federalism has changed dramatically. In 2005, Ambassador Astrabadi is correct, you really had two people sitting at the table. You had the Kurds and you had the Islamists, the Shia, which was really a political elite that probably did not have its finger on the pulse of even the Shia population with regard to federalism. And the Sunnis were sitting completely outside the room, altogether. But the Kurds, they knew what they wanted, and they've remained consistent to today. They want this decentralization, they want this autonomy, they don't trust Baghdad at all, and for them, constitutional discussions have been since day one, we are not going to lose what we gained between 1991 and 2003. The Sunnis, let me go to the Shia next. The Shia are much more conflicted, and even were in 2005. I do disagree that there was this monolith view of the Shia wanting, this region of 9 provinces in the south, the Shiistan, as it's been referred to here, because they were really torn over their own experience. On the one hand, they were this persecuted majority under Saddam Hussein, and felt that the only way we can protect ourselves, as the Kurds feel the only way they can protect themselves, is to have this region with this immense autonomy, and just by luck, we happen to have all the oil as well, or the vast majority of it. This makes sense. At the same time, they're scratching their heads thinking, wait a minute, we're 60% of this country. We're the majority. Why not, get a bigger piece of why not try and go for the whole pie? Let's govern, let's control the national government. Why would we want all this decentralization for ourselves when we can have control over just about everything? And they remain conflicted over that today. You throw in what's been said about Arab nationalism, and I do believe that for the vast majority of Shia even, there is not much of an appetite for this regionalization, and yet it's there in the Constitution. It's constantly going to be a temptation. Basra tried it in 2009. Basra's trying it again today. Different political forces within Basra are moving to regionalize, and it's very interesting, although maybe a bit too inside baseball. Who's the engine behind that movement? The Sunnis have come the furthest in their outlook on federalism. Federalism in 2005 was the F word. It was the dissolution, the disintegration of Iraq. Well, today they are the minority, and they are in fact the minority with no oil, in their territory. And they want to simultaneously strengthen the federal government for that reason, but recognize that a little more self-rule would actually be in their interest. And my point in raising all of this is because I agree with Ambassador Rahim completely. And Ambassador Stramati, the constitutional moment in 2005 was probably too soon, but it was definitely too fast. And the outcome of that is that the discussions and the evolution of views about federalism among Iraqis that we see over the last 5 years, there was no moment to have that discussion when the Constitution was actually being drafted, and we missed it. But the parties, all of them, have come a long way. The Kurds, I'll tell you, I was talking to them in 2007, and they actually are of the view. In an ideal world, they would love to see symmetrical devolution, everyone its own region, because that would weaken the federal government even more. But they are prepared to say, we're not going to give up what we have, but what happens in the rest of Iraq, let the Arabs decide. And there is the potential for this asymmetrical system, which I believe is the most logical outcome. It's where Iraq is today. If you were to refine it and entrench it constitutionally, I think it does provide the best chance for effective governance and more stable politics, at least within this discussion of federalism in Iraq going forward. Thank you very much.
So that was Jason Gluck, not David Tafori. We owe you a great vote of thanks for elucidating the nightmarish complexities of this situation. For a second time, may I introduce David Tafori?
Thank you so much, and thank you to the University of Pennsylvania Law School for planning this excellent event. We don't talk about these things enough in this country, especially about rule of law in these two conflict countries, Iraq and Afghanistan, and I've greatly enjoyed the presentations by the three speakers who came before me. I'll try and keep my comments short so we have time for questions. As was mentioned in my introduction, I served as the rule of law coordinator for the State Department in 2006 and 2007, working in the embassy in Baghdad. As all of you, or many of you know, we also have PRTs throughout Iraq, and during that time and still now, we have rule of law attorneys in each of the PRTs, and I traveled quite frequently in my position with the embassy to visit the rule of law lawyers who were working in the PRTs, and was able to get a pretty good sense of the state of the legal system at that time. As was not gone into in detail in my introduction, I am now back in the U.S. working in Washington for a law firm as a partner at the law firm of Patton Boggs, and I spend a lot of my time now focusing on assisting clients with investing in Iraq and also in Afghanistan, but primarily Iraq, and also assisting with policy matters related to Iraq and continuing to do some rule of law work. But the primary work that I do really is helping clients, U.S. companies and other Western companies and foreign companies understand how to operate in Iraq and how to comply with Iraq's laws, which can be challenging. So what I will try and do is bring a little bit more of practitioners' perspective to these discussions. My colleagues here, who are very distinguished scholars, gave great presentations. My presentation will be slightly different with a slightly different focus, and I think at the end of it you'll find that I'm a little bit less pessimistic about the prospects for federalism to result in an Iraq that is successful and that is stable and that ultimately provides security and prosperity for the people of Iraq. When I was in Iraq, we basically focused on three things in the rule of law mission for the embassy and for the State Department and also for the military. One was strengthening the independence of the judiciary. Two was protecting judges. At that time, and even still now, judges face major threats in Iraq, especially if they're trying cases. And three was just getting the criminal courts operating again. In 2006, very few criminal courts were even operating at all in Iraq. So there was almost no judicial process at all for prosecuting, investigating, prosecuting, and ultimately convicting criminals in Iraq. That was those three focus. We had that focus because of the situation at that time. Things have progressed a little bit, and certainly the focus has changed. At that time, federalism was something that I think the judges of Iraq fully understood that they needed to enforce and protect and plan for, but they spent little time making it a priority. For instance, Iraq has a very established court system, and it was understood at that time in 06 and 07 that it was possible that Iraq needed to set up provincial courts and regional courts in order to fully put in place a federalism structure. But Judge Medhat, the Chief Justice of Iraq, and the other senior judges really didn't spend any time thinking about how to do that and whether to do that. What they did spend a lot of time doing is trying to strengthen the independence of the judiciary. And I think on this point, Judge Medhat had great foresight. He understood that the judiciary was newly independent and that the concept of an independent judiciary was not understood by the people of Iraq, really wasn't understood by most people in the government of Iraq. And so a lot of his time was simply spent trying to enforce that principle, to put in place laws that made clear that the judiciary was independent, it had an independent budget, that it had independent authority, and that it was not subject to the decisions of the executive branch, as it was under Saddam Hussein. And that was quite a challenge. And the ambiguities in the Constitution don't just apply to the federalism structure it's set up. It applies to, there are a lot of ambiguities in the Constitution, including on what it means to have an independent judiciary. But what the Constitution did do with respect to the judiciary is it called for the passage of implementing laws, including a law to govern the federal Supreme Court, which was a new court envisioned by the Constitution, and also a law to govern the Higher Juridical Council, which would govern the whole judiciary. And we spent a lot of time really struggling with certain issues and certain language in the Constitution. For instance, the Constitution calls for the federal Supreme Court to be made up of judges with different background, including Islamic law judges. But the Constitution does not spell out what that means. So we spent significant time trying to figure out whether the federal Supreme Court really had to have Sharia law judges on the court. Judge Medhat and most of the judiciary the established judiciary, we're very much against that as really changing the entire concept of the judiciary as being secular. So that was one of the things that we struggled with. I wanted to talk a little bit about the Kurdistan region, which is, of course, the only region that's been set up under the Constitution. The Kurdistan region already had courts that were completely separate from the rest of Iraq, as Jason mentioned. But with respect to the courts in the Kurdistan region, they are operating pretty well. The judges are not as well trained or well educated, perhaps, as judges in the rest of Iraq, especially because since 1991, they were not able to be trained in the Judicial Training Institute. However, the Kurdistan region went forward with setting up a judiciary. And I think it's fair to say, while it's totally separate, the judges in the Kurdistan region understand that appeals can be made from their courts to the federal Supreme Court for any cases that involve constitutional issues. That's very clear in Article 93 of the Constitution, and I think it's widely recognized by the Kurdistan region judges. So the principles of federalism are really best exemplified in the Kurdistan region, not just in the judiciary, but in pretty much every aspect of the government. And as Jason mentioned, the federal government has little to no presence in the Kurdistan region. I, for one, don't necessarily see that as a problem. And in fact, in practicing and assisting clients with operating in the Kurdistan region, it doesn't normally pose a problem. The Kurdistan region, while it's beginning to pass its own laws, it has its own judiciary, very few of those laws are in direct contravention of any federal laws. So it might be that, okay, if Baghdad cannot execute its full responsibilities in the Kurdistan region. Moreover, as Jason mentioned, the problem of accountability and transparency will not necessarily be cured by extending the authority of the central government of Baghdad to the provinces and the one region, the Kurdistan region. There are problems with accountability and transparency in both governments, but certainly no one would say that the Baghdad government is so accountable, so transparent, so effective that it needs to have a greater presence in each of the provinces, in each of the regions, or the region, in order to strengthen accountability and transparency throughout Iraq. Where I think we're going is a completely different direction, as the other two speakers mentioned. I think provinces will continue to have more power, and they will continue to take more responsibility for governing. And I particularly see this in the investment arena. Foreign investment is absolutely necessary for Iraq's future, especially as aid and assistance decreases from foreign countries in Iraq. And the key to Iraq's future is harnessing its mineral and oil and natural resources, managing them properly, and distributing the proceeds of those resources properly. Again, that is not something that the federal government in Baghdad has done a very good job of. The federal government has been in charge, essentially, of all existing oil fields since the Constitution was enacted and before. And oil production has stayed flat at 2.5 million barrels per day, despite lots of effort and the spending of lots of money by the Ministry of Oil in Baghdad. Now, there is hope that the Ministry of Oil in Baghdad will get stronger, will get better. There are new oil deals in place. There are new efforts to strengthen the oil sector, but the performance so far, it is not debatable. It has not been very good. What this has allowed, what the Constitution then enables through the federalism structure that's set up and the principles in the Constitution with respect to the hydrocarbon sector, is the possibility for the region, the Kurdistan region, any other region that forms, and even provinces to manage their own oil and natural resources. And I think that's probably where we're going, that more provinces are going to begin to take more management control for the oil resources within their territory. And that is not necessarily a bad thing. I disagree with the suggestion by my colleagues that the Constitution doesn't govern how oil proceeds will be used. Article 112 is very clear that the oil and natural resources of the people of Iraq are owned by the people of Iraq. It also provides pretty clearly that the federal government has responsibility to distribute those proceeds in a fair manner. Now, in practice, you can question whether right now the proceeds are being distributed in a fair manner. But what you can't question is the fact that the federal government does control the oil proceeds. Proceeds from all oil go to the federal government now, even proceeds from the Kurdistan region, from the producing oil fields in the Kurdistan region. And as part of the bargaining over the hydrocarbon sector, the Kurdistan regional government is not, at least now, insisting that they deserve to get those revenues and keep them for themselves. They have acknowledged, under the principles of the Constitution, that even for oil fields that they help manage within the Kurdistan regional territory, those proceeds need to go back to the federal government. So not only does the Constitution provide that the federal government does control the revenues from the oil sector, the only region that's been formed is abiding by that and has acknowledged that it will abide by that. And I think that we can expect that if other provinces and if other regions are formed, other regions also abide by that we potentially have a much better system for developing Iraq's oil resources. New fields will be managed by the provinces and regions in which those fields exist. However, the proceeds will still go to the federal government, and the federal government will be required under the Constitution to distribute those resources fairly throughout the country. Now, absolutely one of the things that needs to happen for Iraq to continue to be stable and to prosper is for there to be a deal worked out with respect to the hydrocarbon sector. There is a draft law that's been pending in the Council of Representatives since 2007. It hasn't moved. It's subject to significant gridlock in the Council of Representatives. But I think while there has been gridlock for so long, I think it is possible that a deal could be worked out. And I think that's one of the things that the new government, once it's formed, will have to tackle immediately. And the way it needs to be resolved is along, there are essentially two basic disagreements between the Kurdistan region and the central government and the other participants in the bargaining process. They are how, not whether revenues should be shared, but at what percentage they should be shared. In other words, what percentage of the revenues should the Kurdistan region get? And two, who has responsibility for managing oil resources? And there is some ambiguity in the Constitution, but it's at least a fair read that the Constitution provides that for existing oil resources, the federal government manages, and for new oil fields, the regions or provinces govern. And if a deal can be worked out along those lines, and if a hydrocarbons law is passed, and all parties abide by the principles of the Constitution and share those proceeds with the federal government and allow the federal government to distribute them, federalism, at least with respect to the most important part of the economic sector, could be successful. The only other comment I would have is that with respect to investment, while Baghdad and the Kurdistan region do not work together necessarily, they are not usually, at least in my experience, adverse to each other in terms of promoting investment. And indeed, both have passed investment laws which are actually quite similar. There are a couple of very slight differences. So for an investor who feels challenged by the fact that there's a separate government in the Kurdistan region, once they get to understand the economic framework and the laws governing investment, they normally don't find it too difficult to invest in both places. And except in the oil sector, they don't have any problem getting deals both with the central government and with the Kurdistan regional government. And again, if that process continued, the hope, at least, is that federalism could be a successful framework for supporting foreign investment in Iraq. Thank you.
Thank you. Thank you for that wonderful analysis of the implications of federalism for economic development. I think we have a bit of a dilemma now because we only have, I think, 12 minutes left. Do you want to exchange ideas among yourselves, or should we throw it open to the audience?
I just want to make a very quick comment, and that is that Article 112 of the Constitution does not explicitly give the federal government the right to collect revenue from oil, either to market oil exclusively, or to collect the revenue from oil exports exclusively, or to distribute exclusively. All it says is that it will manage the oil sector and that revenues shall be distributed. Is it 111? Okay. And actually, it's 112.
It's 112.
112. And in fact, and I have the Arabic copy of the Constitution with me, and I've checked it and rechecked it. And by the way, the Constitutional Review Committee actually noted this, and one of its recommendations is to add the exclusive right to collect and distribute revenue and to market, because it wasn't there in explicit terms in the Constitution. Again, I'm not saying it's not that it was not explicit. It is one of those vague, ambiguous statements.
Yeah. Can I build on that for 1 second, and then you can respond? Because not only does 112 have this ambiguity and really focus on management as opposed to revenue, but it does say that the federal government is responsible for distributing the revenue based on the population distribution in Iraq. And 121 says the same thing when it says that the regions shall get national revenues based on the percentage of their population. Now, this isn't a problem for the functioning of the federal government today because Baghdad controls 15 provinces, 2/3 of Iraq. But if each of the provinces were to regionalize, if all of Iraq were to be regions, then constitutionally, all of the revenue that's collected has to be distributed based on population to those regions. Well, the population captures 100% of Iraq, and therefore there's actually nothing constitutionally left over for the federal government. And the only reason this hasn't been a problem is because politically, the national government has enough power to negotiate just bilaterally with Kurdistan. That's not necessarily going to be the case when the rest of Iraq regionalizes, if they do. And the last point I'd make is this idea of regional law trumping national law on revenue absolutely exists. And Kurdistan, in fact, in 2006 or 7, I think in 2007, drafted a revenue-sharing law for the revenue that they were going to derive from oil fields in Kurdistan, and said, under this law, we will share our revenue with the federal government. We'll give it to the federal government to distribute. Of course, they had to say that because 93% of the oil actually comes from outside Kurdistan. But they even put a string attached to it. They said, so long as the national government complies with the following criteria, and one of those was resolution of the disputed territories, or at least treatment of the disputed territories favorably to Kurdistan. So here you have an example of Kurdistan actually trying to extort the national government in exchange for giving up their revenues, which they constitutionally don't have to do.
On the point of Article 112, I fully agree, and I think as I mentioned in my comments, there is significant ambiguity in what it says. But it clearly contemplates that the federal government will have a role in collecting the revenues from oil resources and in distributing them. And it clearly requires the federal government to distribute them in a fair and equitable manner. And that's enhanced by Article 111, which states that all oil is owned by the people of Iraq. In practicality, all parties are also following the existing laws on the books in Iraq, with respect to the oil sector, which require that the proceeds of all oil revenues be provided to the Ministry of Oil, specifically the state marketing organization, and that it has sole responsibility for selling the oil. And that is, in fact, what is happening. That law could be changed, but it could only be changed by an act of the Council of Representatives in which all the people of all regions and parties would essentially be represented in the decision-making process on whether to change that. I think that's all my comments on that point.
Thank you. Alas, we have very little time for questions. It's only going to be about 6 minutes. Could I ask anyone who wants to ask a question to be very, very brief and succinct? Yes?
Yeah, I spent a significant part of my career as a practitioner in the Arab world, especially in the United Arab Emirates. And I think I've been very interested in this question of law reform. Law reform is two things. It's the top-down issues of constitutionalism, federalism, separation of powers that you've been talking about. But there's also bottom-up issues. The enforceability of contracts, property rights, individual rights, which I think you really can't have one without the other, because the bottom-up issues help build trust, build institutions, and hopefully create prosperity. I'd be interested in the panelists' views, and especially the Iraqi members of the panel, on the extent to which there is a functioning court system in Iraq now that would respect property rights and other individual rights, and would provide effective and timely enforcement of those rights, and how that could go hand in hand with sort of the top-down issues that you've been talking about.
Who would like to address
Well, let's distinguish between property rights and individual rights. By the way, I am not a lawyer, so this is not my specialty, but if I'm wrong, I'd like to be corrected. Iraq has a very long tradition of property rights, of respecting property rights, and property right issues being dealt with by the court system. And it is actually one of the best and most respected, although we had an interim period when there was nationalization and so on. But otherwise, property rights, as far as I know, are preserved. When you come to individual rights, that's a completely different issue, because individual rights for many decades were not something that were enshrined in any constitution, or certainly that was not respected. We have a lot of issues now about, for example, I mentioned women's issues that entail individual rights. You can talk about political and civil rights. The press in Iraq has come under a great deal of pressure, and they have not been able to take cases to the courts. And I think what Ambassador Strabadi told us about The Guardian, I believe that was in Iraqi courts. So I am less certain about the sanctity of individual rights before the court system, but much more certain about property rights.
Other comments?
Well, I mean, I think the property rights are very well secured in Iraqi codes. The only response I'd really make is I don't know that it's really bottom up anyway. There is no bottom up. Provincial law doesn't protect these rights. It's all national law. It's all top down.
What about that on the ground? Do the courts give timely enforcement of a contract dispute or disputed ownership of property? Can you go to court and get timely resolution, timely and effective enforceable resolution?
It's getting better. And David, I mean, you work directly with the courts. It's getting a lot better because they've been training more judges. You know, there was a dearth of judges immediately, you know, in 2003 to 2005, but they've been training a lot of judges to improve the speed of adjudication.
Yeah, I would say that the American Bar Association did an assessment, a judicial assessment of Iraq, and then also a separate one of the Kurdistan region. And what they found, and I believe the assessment was in 05, 06, what they found at that time was that for commercial disputes, contract disputes, for small claims and civil claims, that the courts were operating pretty well, much the same as they were under Saddam before 2003. The problems and stagnation with respect to the court system had to do with the criminal cases, and specifically major crimes cases. With respect to for parties that obtain a judgment in an international arbitration to enforce it in Iraq, that would also add some certainty. But the bottom line is the law is pretty good, but still the courts are untested in this area.
I've been given a reprieve. I think we have a little bit more time. Yes.
My question relates to the disputed territory, especially Kirkuk. What is the population composition of Kirkuk? And also, in what federated region does it lie now?
May I start? What is the composition of the population of Kirkuk is what the whole problem is about. Is it mostly Kurdish? Is it mostly Arab? Is it mostly Turkoman? We know it's not mostly Christian, but if you add up the claims of all the three that I mentioned, you come up with 250% total population. So the question is, who is the largest population? And the other problem is that Kirkuk is both a city and a province. It is not now part of any region. The Kurds in the Kurdish region want to add Kirkuk province and city to the Kurdish region on the claim that the Kurds are historically the largest population. But this is contested, and by the Arabs, by the Turkoman, and sometimes it is contested for the entire province, sometimes it's contested only for the city, and so on. So this is the mosaic of Kirkuk is very problematic. You also had Arabization in Kirkuk. You also had probably reverse Kurdization of Kirkuk after 2003. It is very problematic, the kind of tampering that has been happening in Kirkuk after 2003 by both Kurds and Arabs and Turkoman, or not both, three parties. So it's a mess. It abuts the province of Suleymaniye, which is part of the Kurdish region.
And the only thing I'll add to that is the recent national elections resulted in the number of seats from Kirkuk being exactly evenly divided between the Kurds and the Arab and Turkoman who ran jointly, contested jointly. So it's an exact 50-50 split based on the most recent election results.
I think Ambassador Istaravadi does want to make a comment here.
If I can, very quickly. There is the last census taken in Iraq that everybody agrees was a fair census was taken in 1957, which was before I was born. When we were drafting the interim constitution, I was advisor to Dr. Adnan Pachachi. We obtained a copy of the 1957 census from the Ministry of Planning. The 1957 census, as all prior censuses in Iraq, did not ask what is your nationality. It asked, what is your first language? For Kirkuk, the response was 30% Arabic, 30% Kurdish, 40% Turkmen. Whatever that means. Now, you can do the census in Iraq and ask a city, in Baghdad, I mean, a city that is actually the largest Kurdish city in the country. And you would find a very healthy percentage of the ethnic Kurdish population of Baghdad whose first language would be Arabic. The great Iraqi poet Bulend al-Haidari was ethnically a Kurd, but he couldn't say good morning in Kurdish. and was a poet of the Arabic language. So I don't know how this coincides with the actual ethnic divisions. And then there have been the problems that Ambassador Rahim has talked about of Arabization, then Kurdification, but that in any case was the last census that was done that anyone relies on.
Thank you. See, in the back there. Yes.
As I listened to your presentations, I wondered whether the most fundamental problem is a constitutional problem or a nationhood problem. And if the latter, I would be curious if for each of you, Kurdish independence is something that should be on the table.
I'm sorry, I'm not sure what you mean by nationhood. Are you talking?
Using the term nation in the sense it was used around the time of World War II of a people. So you might call the Kurds a nation, you might call the Sunnis and the Shias nations.
Well, in my view, that the Constitution, some of the ills of the Constitution, or the defects of the Constitution, or the ambiguities, is because there were ambiguities in self-identification, in the way they looked at the future, by the people who actually wrote that Constitution. So the two things are not completely separate. Although there was a lot of international input, American, UN, British, or advice, it is ultimately Iraqis who wrote that constitution, and it reflects some of the anxieties they have, some of the uncertainties and insecurities they have about themselves and about how they relate to that country. I've brought up the issue, and I need to say that, of course, the Constitution was written, and this is really important actually to mention. The Constitution was written largely by Kurdish politicians who had been more or less independent since 1991, for 12 years, and who had ample time, and who had in fact published a draft. They had their own constitution, and they had published a draft of the Iraqi constitution as they saw it. In the other party was a group of Shia exiles who had returned to Iraq after many years of absence, and who for the most part belonged to the Shia religious parties. And I think to know that it's really important to fully understand the import of this in looking at the Constitution. These were two of the most persecuted groups. The Kurds had been separate from Iraq for 12 years. The Shia had been out of Iraq for much longer in different countries such as Iran, Syria, Europe. And they came with their confused and uncertain idea of their identity, of what Iraq was like, and also with a huge sense of their persecution in the past and the need to protect themselves in the future. They looked at Iraq as the Shia are the most oppressed and the most persecuted, and they're a majority. They must now rule. And the Sunnis are at least associated with our persecutors. They have to atone for their past, for the crimes of the past regime, and so on. And so the Kurds are our friends and brothers because they were our fellows in persecution. They had this atomized view of the Iraqi population, which was reflected in the Constitution. I'm not sure if I answered your question, but I think it's in part a question of identity, and the Constitution only reflects that. It's an issue that pervades all our politics today and has created problems over the last 7 years.
Thank you so much. I've been given a signal that I have to wind things up now.
It took so
No.
long.
Can I make a point?
Well, quick.
Yeah, no, I just, directly responsive to your question, I think it's interesting, without weighing in on whether I think Kurdistan should be independent or not, I think it's ironic that Kurds who so vehemently, passionately want independence, it's probably not in their best interest to have it. They rely on oil generated from Basra, from Iraq. They can't even pay their own civil service and army without oil money that's generated outside Kurdistan. They would immediately have 3, if not 4, hostile neighbors. And the oil that they have in their country, we wouldn't be able to export it. The Arabs, who have this passionate attachment to Kurdistan and this national view of what Iraq is, would probably, in many respects, be far better served by letting Kurdistan go, keeping the oil, getting rid of this, governance disaster because you have this autonomous region and the politics that it creates in Baghdad. I mean, it is ironic, again, without expressing a view on what the best outcome is, that the parties espouse views that are probably the exact opposite to what's in their own best interests.
Let me make one quick point. My answer to that question is that I would not try to answer whether Kurdistan should be independent or not. That's a question for the people of Iraq. What I do believe is that the compromise embodied in the Constitution provided the minimum safeguards that the Kurdistan region wanted and felt it needed in order to stay part of Iraq. And I think if they are able to continue to have those types of safeguards and continue to have some level of autonomy similar to what they have now, they probably will stay in Iraq.
Thank you so much. As you can see, our panelists have been willing to wrestle with agonizingly difficult topics, and I think you will join me in saying that they've offered us an exceptionally insightful and valuable analysis for which we're all very grateful. Thank you so much.